Now, obviously, this is a legal online course, so I want to explain a couple of the relevant legal issues to you and what you want to think about when it comes to a service agreement. So, the first thing to know is that the service agreement issues will almost always arise in consumer protection laws. So, consumer protection laws are something that says anyone who buys something has a certain amount of automatic legal rights when making a purchase. The origins of consumer protection laws, and it's important to just understand the concept of this as we get into the service agreement and what should be included and why it's included. But the reason why is there is a disparity between big companies and individual consumer, where government said over time, well, okay, because there's such a vast gap in resources and ability and marketing and all of these other issues, we want to make sure that the individual consumer has basic rights. And that if they're paying for something, they're allowed to make sure that A, they get what they're paying for, that it's of a reasonable quality, that it's the same thing that they told they were going to be purchasing. And all of these rules are just inherent. They come included with the relationship of any purchase that you made, whether you knew that or not. But for our clients, when there's a sale of service between a business and an individual, consumer protection laws will apply. The other thing about consumer protection laws is that they will vary on a state-by-state basis, but with general principles, and like the general principle always is like, be a good person. That doesn't mean that you have to give things away for free, but by being a good person, and I think because by virtue of you being involved in a community that's given you access to this course, by being a good person, I mean like, don't take advantage of people, don't sell people something that you can't deliver, don't sell people something that's broken. Like, that's the general golden rule when it comes to consumer protection rules. But there are other nuances to know in terms of customer remedies. And some of the biggest areas that we've seen in client service agreements in terms of remedies are when people are on auto pay memberships, which means at the beginning of each month, you automatically take money from their bank account and you continue to do that for a period of time. There are very, very strict rules that apply to auto pay memberships. As well, if someone is signing up for if they're buying a membership for 3 months or for 6 months or for 1 year, the longer time that someone has made an investment for, so if I've paid an annual membership, the longer the time that investment is made for, the more remedies they're going to have to cancel in the earlier phases of the relationship. And that's, again, that just comes to this policy that, okay, if someone bought something for a year, we want to give them a period to, make sure they're satisfied and everything is as it should be, so that it's not like they can buy it for a year. The next day, if they want a refund or a cancellation, it's difficult for you to say, no refund or no cancellation. And that's, a lot of our clients don't always understand what really comes behind a good refund or cancellation policy. But one of the factors that's really important, and California is the leader in this because California is sort of the leader in a lot of these legal issues, is making sure your documents are drafted correctly in abidance with these rules around auto pay, and understanding that there are variants of the duration of how long the membership is for and how long someone pays for. Their rights will necessarily be different. So in addition to the specifics around consumer protection law and service agreements, another thing that you have to keep in mind, and this is what we really saw happen more so mid-2020 to the start of 2021, but it's still something to keep in mind. One of the rules of consumer protection laws is that if you are selling someone a service, or they've prepaid for a service, or they've paid for a service, and you're not able to deliver on that service, at law they're automatically entitled to a refund. So there's no question. If you've sold someone something and you're not actually able to deliver on what they've purchased, the moment that you're unable to deliver on that particular purchase, the person is entitled to a refund. Now, why this matters is we've seen a lot of wellness and fitness businesses pivot really quickly. So it used to be that everything was done in person, then everything was done online, then we came up with a membership, now we're offering services in the park. finally returning to the studio, and there's all these different ways that our services are being offered. And all of that's awesome, and we love clients who pivot, because pivot means that there's still blood flowing through your business and you're still able to offer your services. Now, the thing that you need to keep in mind and make sure of is that the service agreement has to capture the different ways that you are offering your services. And you always want your service agreement to be up to date with the way that your business is performing. So one of the issues that we saw a lot of our clients go through was they had service agreements for their studios. Someone comes into the space and is going to be doing the activities there in the physical space. And then, okay, we went online, we've been online for 6 months, but we're still using the same membership agreement or the same service agreement. Now, at law, because the legal agreement that was made between the parties was for, in-person services at the physical location of a studio, we saw a lot of clients get chargebacks, and a lot of our clients lost a ton of revenue because people said, nope, even though I signed up for this membership, it doesn't say anything about doing things online or online classes, and therefore I want to leave and I want all my money back from this, dating back to this particular time. And how that legally unfolds is that the member or whoever signed the service agreement will speak to their credit card company and say, okay, well, I paid for this service, but they did not deliver. Here's a copy of the old agreement that we had for the way they used to do business, and I'd like a chargeback. And so whether it's a third-party processor like Stripe or whether it's the credit card company itself, their first position is to side with the consumer. So they'll give a refund, and then the onus would be on the small business owner to prove that, in fact, the relationship was not that way and that they had agreed to these services performed in a different way. And more often than not, you'd lose. And I've seen clients lose millions of dollars. I've been part of that process, and I've spoken to credit card companies, and I've spoken to third-party processors in that. And so I just share that lesson because I think as things are changing and the way things are changing in the wellness industry and for health and fitness, you want to make sure that your service agreement captures all the different ways that you offer your services. And often clients will sort of give me feedback or be resistant to reintroduce documents to their community and say, hey, you know what, I'm concerned about getting my clients to re-sign this agreement. How do I go about doing it? And it's really simple, because all you have to say to them is like, hey, the way that we're offering our services have changed. And as such, we need you to agree to the new relationship that we're entering into together. And even if one sentence or two sentences is different, if you have the implementation in a very simple HelloSign, DocuSign, Waiver King, whatever it is, there's a lot of softwares that are really, really easy to use. Or, if you're using your own software and that's how clients interact with you and sign agreements through your software, it's easy to implement that. But from a legal standpoint, you have to have your service agreement always be reflective of the services that you offer. And the times that we've seen clients run into problems is if they're using agreements that aren't theirs and don't reflect the relationship that they have. That's always a problem. If we see clients using agreements from someone else that they don't understand, that's a problem. And when we see clients offering services in new and different ways and not having the agreement represent that, that's a problem as well. What the service agreement really is about is getting clients in the door, making sure they've agreed to the terms that you want, and then never having to think about this again. Like at Conscious Counsel, success for us is that we set clients up with awesome documents, and they never have to review or look at the documents again, because everyone is on the same page. Everyone understands exactly what they're getting into. Everyone understands what the rules are, and we never have to circle back on it ever again. The issues that we run into is that the agreement doesn't capture the relationship, the agreement doesn't capture the services, and then our clients run into big problems. And for me as a lawyer, I'm like trying to help my clients resolve these problems, looking through the agreement, like praying that I'm going to see the one provision that I need to see to help us. And more often than not, it's not there when the documents aren't drafted specifically for the clients. So in summary, the things to understand about the service agreement and how it relates to the law specifically and what you need to be aware of and why it needs to be updated is that all of it relates to consumer protection laws. All of it relates to you being able to keep revenue. You've done the hard work of actually selling. So now we need to make sure on a legal end that you're able to keep the money, and having the right agreement with the right provisions that abide by relevant consumer protection laws will ensure that you are able to keep that.